This is Jeffrey Tucker, President, Brownstone Institute. I'm very pleased today to have with me Stephan Kinsella, attorney, who's the author of a 2001 article called Against Intellectual Property, and more recently, a large treatise called The Legal Foundations of a Free Society. One of the most important thinkers of our time, I think. He's had a huge influence on me at some point in I'm going to say mid 2010s, because his article came out and I thought it was probably not correct. I thought it was wrong. At least I thought it was a distraction. Essentially, what the article says is that intellectual property is an illegitimate concept, that ideas cannot be commodified and turned into property, and the attempt to do so is destructive of market forces and information flows in society. In particular, this pertains to copyrights, patents, and yes, even trademarks. The thesis is shocking, and probably as you're listening to this, you're thinking, "Oh, that can't be true." Then nobody would have the incentive to create, and so on. Like, these are the usual comebacks. But I promise you, if you read the article, think about the subject enough, as I did for years, you eventually come to be persuaded. And it was because of that that I shifted in my own career to only publishing within the commons, because there was sometime in this period an innovation of the copyright status that that made available to publishers what's called Creative Commons, with a number of different licenses and terms of use. So I, in my own work, embraced a Creative Commons license with only one provision of attribution. And that has been, I think, a real key to the success of many of my own personal projects. And also, as a publisher, Brownstone only publishes in the commons. And as far as I know, we're the only. There may be other nonprofits that do it. I don't know, but I don't know about them. I'm not familiar with it, but it's a completely different model. One thing about this model is that it prevents conflicts between the publishers and authors, so that if an author doesn't like what Brownstone is doing, doesn't think we're marketing it enough, doesn't like us anymore, they're free to take it back and go to another publisher. We're not holding anybody against their will. That prevents conflicts, whereas normal publishers not only retain copyright, but then, as tied to that, distribution rights, which last for the lifetime of the author plus 70 years, which means that an author's grandchildren are the ones that will be responsible for getting the work back in print at some point. And most authors have no idea what they're getting into when they enter into these contracts. It's actually quite sad. The patent issue is another matter entirely. It's practically destroyed innovation in the software world, unfortunately, and innovation in many aspects of life, and led to vast corporate cronyism. And as far as the pharmaceutical industry is concerned, enormous amount of unspeakable corruption in pharmaceuticals as a result of patents. Today, I'm not going to rehearse all these arguments on this particular topic, although it's important to understand them as background. But I think what we're going to do today with Stephan is discuss a much more difficult and related topic, which has to do with the issue of defamation, which is a major problem in the world of the internet, where anybody can just go on the internet and say anything about anyone. And it's the courts have always said that that they've set very high standards for defamation in the case of public figures. It hardly ever works to sue somebody for defamation. So we've got a kind of a defamation free-for-all going on, and this is made much worse by the NDAs, which are ubiquitous in the corporate world today, so that everybody's under some kind of non disparagement. Which has provided a kind of a license for defamation on the internet. Stephan takes an unusual position. I think I'm just going to use this interview to explore this a little bit and any other related areas. Welcome to Brownstone Show, Stephan. Thanks for coming.
Thanks very much, Jeff. Glad to be here.
So let's start with the basic. I mean, let me just say in the outset, it connects with a certain intuition. I think in British common law and just normal course of life, that there's something wrong with defamation. I mean, you have to think about it this way. Would you rather have somebody steal a potted plant off your porch, or have some major account smear you all over the internet as an evil, terrible person in ways that you can't contradict? I mean, there is a sense in which it seems defamation, there are conditions under which defamation is like potentially more injurious to the individual than, say, petty theft. So you recognize that, right? And that's the source, I think, of defamation law.
Absolutely. I think that the intuition is that kind of the rough approximation of the law is that the law is there to stop you from being harmed, right? It's to stop harm.
That's it.
And that generally acts of aggression harm you, which is why the law prohibits aggression and theft and things like that. And our general moral intuition tells us that there are things that are wrong and things that are right. Honesty is good and right, and dishonesty is wrong. So lying is wrong. So those intuitions are not, they're not incorrect. But what we do in the law is we identify a subset of things that are wrong that the law can regulate. Okay. So just because something is immoral or wrong doesn't mean it's going to be a crime or an offense under the law. So it is true that if you lie about someone, it's wrong. You shouldn't do it. It can harm them. But then the question is it the type of thing that causes harm that the law should recognize? Is it really a property rights violation? And the more subtle understandings of, and the more precise understandings of property rights and aggression leads you to understand that fundamentally the law is about protecting individual rights or property rights from aggression or trespass. And they can only be violated from the use of force, which is why the kind of Ayn Rand idea was that you can only have a law that prohibits the use of force against someone. So then the question is,
let me ask you to pause there.
Yeah.
And
Sure.
I mentioned that I had a very interesting discussion with Aaron Curiotti yesterday concerning free speech and the exceptions to the idea of free speech. And one is that you can't make physical threats against somebody. Is that right? I mean, you can't threaten somebody physically. You can, and so that proviso is in there, right? So you might be able to threaten somebody with somebody else, like, oh, I'm going to expose you, I'm going to ruin you, I'm going to make your life a living hell. But you can't actually, but it's illegal to threaten violence against another person.
Yeah, the way to look at that is that in general, we have an understanding that there's a state and the state is dangerous. And so when you have the state, it's empowered to administer the criminal law and the legal system. But because of the danger of the state, we have limitations on state power in constitutions. And some of those limitations are formed in the words in the language of rights, but they're really just prophylactic limits on state power. So when the First Amendment says there's a right to freedom of speech and freedom of the press, it has exceptions to it. Like if you use your words to threaten someone, it has exceptions because it doesn't really mean that there's an exception to your rights. It just means that the purpose of that right was there to limit the state in the first place. Right. So you say that there's a right to freedom of the press, and that just means Congress shall pass no law regulating it. It doesn't mean that sometimes your use of your speech or your words is not itself an offense or a tort. Right. So if you want to be careful, you would say that our property rights are the rights to the physical integrity of our bodies and our resources, which means that no one is entitled to use our resources without our permission, right? That would be trespass. But then the question is, what types of actions does this prohibit? And that means any action that is likely to infringe someone else's rights. But of course, in our world, that can involve words. If I'm the jailer and I say, lock that guy away in his jail cell, I'm causing something to happen by my words. If I'm on a jury and I vote to acquit, to convict an innocent person, I'm participating in putting him in prison. If I'm the leader of a firing squad and I say ready, aim, fire, I'm causing bullets to be fired. And likewise, if I'm the president and I say drop a bomb over Nagasaki, then my words are causing things to happen. Okay. And so just because we recognize that there should be rights against aggression and rights against trespass, it doesn't mean that anything that you say goes. So it is true that sometimes your speech can be limited. But then the question is, what about defamation and lies? Can the law prohibit dishonesty? Can the law prohibit lying? Can the law prohibit laziness?
And the law has generally always prohibit defamation, right? I mean, I don't think there's a precedent in Western law, am I speaking to generally, where defamation is just generally permitted, right? And what are the conditions right now that?
And of course,
go ahead.
Well, I was going to say this, in a way, this is linked to the idea of I'm probably not pronouncing it, les magiste, the idea of besmirching the crown and speaking ill of the king. So it's rooted in these ideas too, which are actually a crime in some countries to defame the king or the sovereign, right? Yeah. So a lot of these things are tied to this feudalistic idea and the monarchy ideas. But yeah, so in the article that you mentioned that I wrote about on defamation tries to tie defamation law, which really protects what I call a reputation right, the right to your reputation. That's what it does. The idea of defamation law is centered around what I'm saying is like a type of intellectual property right, like patent or copyright. Now, unlike patent and copyright, which did arise in statute, right? The Statute of Anne for copyright and the Statute of Monopolies for patent, trademark and trade secret law and defamation law did emerge on the common law. And they emerged in response to the idea that it's wrong to deceive someone or to defraud someone or to harm someone, this kind of generalized idea of harm. So yes, defamation law has been around for a long time, and it generally required the publication of false information that harms someone's reputation. So it's rooted in the idea that you have a property right in your reputation.
Yes, and part of this involves, you mentioned harm, but even under the U.S. law, don't you have to, and maybe this is traditionally true under British common law, the plaintiff in this case has to demonstrate, the burden is on the plaintiff to demonstrate that there was an intention to harm. Right, not just like the fact of harm, but the intention to harm.
Well, the standards are all over the map now because the law has changed. But you basically, it has to be an intentional act to be a crime or a tort, and it has to cause damage. But what that means is you have to prove damages. Generally, there was an exception called per se defamation, which means that there were certain classes of defamation which damages were presumed. And that was like if you called a woman a prostitute or something like that, or if you called an attorney dishonest in his dealings with clients, something that went to your profession or something like that. So there are certain classes of defamation which are considered per se.
But most of there has to be demonstration of fiduciary damage of some sort, like loss of.
You have to prove. Sometimes you have to. Usually, you have to prove harm, right? Which is why a lot of defamation lawsuits are brought in England instead of the U.S. Because in the U.S., because of the First Amendment, which has raised the bar for defamation lawsuits in the U.S., it's easier to prove damages in other common law countries like in England because they don't have a First Amendment.
Yeah, and it's actually has led to a strange situation. I think that the press feels less free in England because of the worry about successful defamation lawsuits, right?
Yeah, and of course in England, at least, in most other non-American countries, there's generally a loser pays rule, which is if you bring a lawsuit and you lose, you have to pay the costs of the other side, which is somewhat reasonable. In the U.S., we don't have that, so it makes us a little bit more litigious, which means that there's more of a chilling effect or a bullying effect from the use of trademark law and copyright law and defamation law, which I regard as a subset or type of intellectual property law, which is why I wrote about it. So it leads to a chilling effect, and because people don't understand the nuances of the law, it perversely, as you and I were talking about offline, it leads to the existence of defamation law leads to an enhancement of the harm that defamation can cause. In other words, in a free society with no defamation law, you would always have people tell lies and defame people by telling lies about them. But if it was permitted and legal and there was no cause of action to stop it, then everyone would listen to that and they would take that with a grain of salt. Like they wouldn't necessarily assume it was true because they know that it just might be a lie because you're entitled to tell lies. Whereas in today's world, if someone is defamed and something horrible is said about you, like, you're into octopus anime or something, then if the person who's the victim of that defamation doesn't file a lawsuit, everyone assumes, well, it must be true. Otherwise, he would have sued. So it sort of gives more power to defamation because you have these laws.
Yeah, I think it's a profound point because I mean, like anybody listening right now can think of cases in which they've been defamed on social media at some level, right? And whether you're a public figure or not. But how often would a person bring a lawsuit? That those are expensive. You have to retain an attorney, so you're already deep 5-10K as it is. And the attorneys specialize in burning through that, and then it's not likely to succeed, right?
No, it's sort of an offshoot of you've heard of Brandolini's law, the idea that it's called the BS asymmetry principle. It's the idea that someone can say something so confused and so wrong, but there's so much confusion and error and lies packed into a one paragraph attack. It would take a dissertation to debunk it.
Right.
It's just an asymmetry there. And so you don't even bother to do it. And the same thing with defamation. You can't go around filing a lawsuit or a cease and desist letter for every single slander against you. So people just don't bother after a while. And because the defamation laws exist, the lies have more power.
Yeah, that's a weird conception. Now, in the 18th century or 19th century, America was far less litigious than now. I suppose that there was a bit of sort of laissez-faire in terms of defamation. Is that your impression too?
I think so too. There was a closer tie between the perceived moral harm and the practical. I mean, people had more reputations back then. Look, it's like trademark law. I'm against trademark law as a libertarian theorist because it's gone, in a sense, too far. Like I said, the root idea of trademark is that it's wrong for a merchant to deceive customers, which is a type of fraud. So there's a grain of justification for the idea behind trademark law. But because the state took it over and turned it into legislation under the Lanham Act in the US, they kept adding to it. So they added, for example, an anti-dilution claim, which is like the reputation rights of defamation law. So you don't even have to prove, in a regular trademark suit, you would have to prove likelihood of consumer confusion, which is sort of like fraud, okay? Deception. Not exactly, but close. But you could also just prove that the value of a mark is besmirched or tarnished. They call it tarnished. So in other words, it's just turned into a reputation right. And the same thing has happened with defamation. It's morphed into more than what the original narrow common law conception would have restricted it to, which is sort of like measurable, actual, tangible harms from sort of an outrageous, clearly manifested public lie about someone's reputation.
Now, you're not arguing that defamation doesn't exist or that it's wrong, and you would have no problem with. Well, I'll just tell you, like, um, Brownstone has a lot of fellows. These are scientists that are, find themselves canceled from scientists, journalists, jurists, whatever, who are excluded because of their views, and so Brownstone will take them on as fellows, and our contract is like a paragraph, but the one thing that we ask of our fellows is that they not engage in defamation, right? So, which
Right.
I consider to be sort of intentional
Yep.
lying about somebody, lying about somebody with an intent to harm them.
Yep. No, that's actually something someone should police by private rules of conduct. Just like in universities and in private publishing, you would prohibit plagiarism. You wouldn't want to be associated with someone who's a known plagiarist. Look, the truth is, in a free society where there's no defamation law, either someone lies a lot and they slander a lot, in which case people ignore them, or they're almost always have a good reputation and they almost always respect other people's rights and they almost never lie, but they take that one chance to do it. But when that happens, then they could be debunked. I mean, you could imagine, like you've seen Snopes. Snopes goes around debunking hoaxes or rumors.
At least claiming to, anyway, right?
yeah, it claims to. But you could imagine if there wasn't the litigious legal industry of defamation lawsuits, and if it wasn't a legal thing, you could imagine private solutions would emerge. If I'm, in fact, the private solution used to be, I challenge you to a duel, right? you besmirch my honor, but of course the state has outlawed dueling, right?
Yeah, I know. I mean, I keep imagining that there should be a resurrection of, or at least a rigorous, a well constructed, rigorous defense of dueling in history. I mean, I think maybe it's kind of gotten a bad name. Actually, there's probably something to say for it.
Do you think you and I would still be around if dueling was permitted?
Yeah, one of us at least would have a,
Kinsella and Tucker dead at 41.
I'm not that good a shot. I don't know. I'm not sure you are either. But,
I don't mean us either. I mean, but anyway.
Okay. Yeah, right. Would have been challenged to all sorts of duels throughout that. But anyway, let's just be clear about your very interesting point here. You're saying that the very existence of defamation law and the opportunities to sue for it, and many people do, I mean, like, I have good friends of mine who've dropped six, have deployed unsuccessfully like 6 defamation lawsuits, in the course of their adult careers. I mean, it's not uncommon. I mean, there have been occasions when I thought about doing it, and then I thought, it's too annoying. Like, I'm not. Yeah. But your point is that defamation law, the existence of defamation law, and just the possibility that a judge will accept the case and that a jury would hear the case, provides, in a sense, a subsidy to lies that they would not otherwise have in a world without such laws, right? Yeah. Am I characterizing this correctly?
Well, that's part of the problem. I mean, and by the way, if you were like a pure libertarian or someone like me who opposes defamation law, but we live in a world with defamation law, and the main alternative you have to restore your reputation is a lawsuit. One thing you could do if you're persnickety is you could file a lawsuit, but you ask for $1 in damages, but you just want a public hearing to vet the lies, to see the evidence, and to have an official result exonerate your name. It would be expensive, but at least you could do that and you clear your conscience. Like, I'm only asking for $1 in damages,
But these litigation could last years. I mean, like,
that's
years.
The problem. It's expensive. It's expensive. See, the fundamental problem is that the idea behind defamation law is that there's a reputation right. That's what the idea of harm or damage is, that your reputation is damaged.
Right.
But that implies that you own your reputation. But the problem with that is, say, Murray Rothbard recognized a long time ago, is that it implies that you own what other people think about you, because all your reputation is what other people think about you. And ultimately, if you believe in self-ownership and freedom of speech and freedom of thought, everyone has the right to have whatever opinion they want of you. They have the right to form whatever opinion they want of you. And they have the right to rely upon whatever evidence that they want, even if it's the lies of someone spreading lies about you, or spreading rumors about you. So you just can't own what people think in their own head, which is what's implied by the existence of a reputation. Which is why I do think that, yeah.
What you're saying makes sense in theory. Right. It follows from, certain postulates. No, you can't control, nor should you be entitled to control. And you can't own what other people are saying about you. And what constitutes your reputation is, the collective wisdom of some group of people and what they think about you. And you can't possess that, right? I mean, I get that. Yeah. But still, Stephan, there is a sense that, I don't know, growing out of us, like an old-fashioned perception of what, honor and decency and these sort of things, that you shouldn't live in a world where somebody can just freely trash you in a way that causes you personal and professional harm. I mean, you understand that, right?
I get that, and I think that there's always an intuition that if we identify something as egregious and immoral and wrong, we should pass a law against it. Which is, of course, is the mainstream way of looking at things, because the society has become so overridden with laws and so legalistic. So they think that if you oppose a law prohibiting a certain behavior, that you're in favor of the behavior. Just like if I say I think that the drug war should be abolished, or drug laws should be abolished, that I'm in favor of drug use.
Right.
Which doesn't, if I'm against prohibition of alcohol, it means I think alcohol is a good thing. It doesn't, that of course doesn't follow. Right. Or if I think that you should be free to publish satanic literature or pornography, that means that you're in favor of those things. But of course, we understand the difference between what's immoral and what's a violation of rights.
And then that's
the thing.
And you're making a kind of empirical claim, in a way, that the existence of the defamation. And by the way, I want to elaborate on this in other ways, but you're making an empirical claim that the existence of defamation law actually makes a defamation, in a sense, more rewarding, more compelling, more powerful, more injurious, because of the perception, the public perception that, look, if it's so bad, if it weren't true, you would surely sue and win, right? Or that person would never be saying this.
Correct.
Because they would fear being litigated against as a defamer, right? So just the existence of the law itself gives the calumny, the lie, more credibility than it otherwise would have in a world without defamation law. Is that your point?
Because
right?
because it gives the illusion that, because people have the illusion that there's a functioning legal system and that people can easily just redress their grievances. They can easily debunk libel or slander, and so if they don't do it, they assume that it must be true, right? So it does add. Now, I will say that unlike patent and copyright, which are legislated and which are completely destructive, and I would abolish those in a second, there is some wisdom behind the idea of Chesterton's fence, right? Like, we should be careful taking a fence down if we don't remember exactly why it was put up, right? Now, I do think we have a good view of the history of why defamation law arose, and so I would be in favor of a reasonable limitation on it to start to see, So, but for example, if we had a functioning court system that didn't cost $1 million to file a lawsuit, right, or cost years and years, or if we had an English rule where the loser would pay, so that you have to pay a fee.
Yeah.
Or if you got rid of the per se categories, right? So if you had a more reasonable defamation rule like we used to have that emerged in the common law that was administered by local courts, and that wouldn't be nearly as objectionable. And look, our mutual friend Jeff Deist, who sort of agrees with me on IP, but he's a little bit hesitant with this kind of rationalist, deductivist mode of thinking. His view is that maybe we should be cautious about necessarily wanting to overturn what a common law court would come up with as a solution to perceived harm.
This I think is where I'm going with this. I feel that I feel that same thing. Although I think your point is really compelling. That, and I'm sorry I keep restating it, but I just want to be clear about this: that the very existence of defamation law is a way of the court system, the government, whoever's behind it, sort of announcing to the whole of society, you can presume that anything and everything that you read and hear is not defamatory. Right?
Yeah, and of course, the state itself is immune from a lot of these lawsuits, so they get to piggyback on top of the reputation that their defamation law system builds among private people. So it makes everyone trust what the state says, right? The regulatory agencies, they have to be trusted because everyone just assumes, well, they have to be telling the truth because there must be some legal remedy. You could sue the state, but of course you can't sue the government.
Is there ever an occasion when a government official has been successfully sued for defamation? Has that ever happened? Are you aware of it?
It's the other way around. Like I said, defamation law is rooted in this monarchical idea of lèse majesté laws, but that's kind of what we had during COVID, when if you dared to challenge what the regulatory agencies said, right, what the official bureaucrats said, you got canceled from your employment and from Facebook and Twitter and all these things. So it was like a soft type of defamation law working its way out by default.
Yeah, that's really interesting. I'm going to slightly pivot a little bit in ways that I think probably listeners might have already been thinking about here. You know what it reminds me of, Stephan? Tell me if I'm right to make this little, what it seems to me like a short hop. The FDA is responsible for declaring drugs to be safe and effective. And so you just naturally have to assume that anything at the pharmacy, anything you get by prescription, anything that the doctor recommends to you has been declared to be safe and effective. Oh, actually, the same thing is true, not just pharmaceuticals, but for food, right? We assume that anything that's for sale has the regulators have deemed it to be good for you, safe, not poisoned, and we look to the government to do this. In my own studies of this, and I'm not sure I've even talked to you about this, my own studies of this is that the origin of the FDA was with the Biologics Control Act of 1902, which was lobbied for by the industry itself, because they knew their products were unsafe. There was a consumer revolt against them. And so they went to the government and said, you need to certify our stuff as safe and effective so people will believe us again, and do this in a way that looks like it's cracking down on us. Like you're getting rid of the bad actors and only leaving the good guys to make drugs. So that was 1902. It occurs to me that this is an analogous situation with defamation law that broadcasts to the whole social order. Anything you read is not defamatory. It's true, or it's like passes some plausible truth test. It's the same way with the FDA's regulation of food and drugs. What do you think about that analogy?
I'm so surprised that you found a way to link this to COVID and lockdowns.
No, I'm just pointing out this is an important. It's a huge.
No, it's a good point. I mean,
Okay.
of course, that's what I did with defamation. I tried to find a way to link it to intellectual property as an umbrella term, and
Yeah.
I think now we're seeing that all these things are connected.
Yeah.
So yes, I think it's a good point. I think that it's a public credibility and trust issue. It's part of the reason the state has power is because it. I mean, what was the title of Hoppe's book that you edited? The Great Fiction, right?
Yeah, the Great Fiction.
The state rests upon delusions and fictions and propaganda. People always say the state is not good at anything. It was Harry Brown say the state is not good at anything, but it's good at two things. It's good at destruction and killing, and it's good at deceiving people and propaganda and lying. It is good at that and maintaining this fiction that it's really out for your interest. And it does it through a web of all these things. And I think part of it relies upon the public's credibility, gullibility, or credulity about what the state claims. And they do that because the public has no choice but to trust the regulatory agencies for their meat safety and their milk safety and their food safety and their medical safety.
We have
no
choice because these institutions exist. They didn't exist in the 19th century. And peddlers were coming along all the time, selling this, and yeah, there were unsafe things all over the place: unsafe food, unsafe medicines, unsafe everything. But at least you had your eye out. You were aware of this. And
you weren't as gullible, and private solutions have been crowded out, right? But I mean, you do still have some. I think you've written many times about the Better Business Bureau and these solutions of these certification agencies that emerge to give private reputation guarantees. But there would no doubt be far more of that if you didn't have the government taking the main role in that.
You know, it's very interesting. I have variously toyed with the idea that if we had less, it's a funny thought that if we had far less government, even no government, we would be a more regulated society than we would be now. I mean, that's not intuitively. It doesn't sound quite believable until you think about these empirical examples, like the Better Business Bureau, which I've had some interaction with them, and they're actually they're quite strict. Like if you write and say, "Look, this," I had a cookie from this Argentinian bakery, and it tasted terrible. You should downgrade them. They will look into it. They will find out, and compare your report with other people, and then. And actually examine. Well, maybe you're just this is not an authentic report. Maybe you just don't like the lady, and they take that into consideration. So they're actually very scrupulous about this. And my experience with Better Business Bureaus, they will write you back right away. And they have teams of investigators looking at everything all the time. It's actually quite strict. And another one is Underwriters Laboratory, of course. Like there is there's not a single electronic good sold in this country that doesn't have a UL stamp on it, and that's not because anybody enforces it. I mean, there's no good law that says you can't sell, but there's no retailer in America that would ever, to my knowledge, sell a piece of electronic equipment without the Underwriters Laboratory, and part of the reason is the liability associated with it, right? I mean, like retailers and wholesalers don't want to bear the potential liability for harm by selling unsafe products. This is a system that regulates itself.
Well, it's also it's also reputational. I mean, look, you have so many examples. I didn't notice until a few years ago, but like there's kosher labels on food, which I'm sure all the kosher people know, like the Pariv and the little K or something.
Yeah.
If you go to a store, there's a cookie, like Oreo cookies have it or something. So that's all private. The government has nothing to do with it.
Private. Yeah, strictly regulated. So, here's what's fascinating to me about this, because so now we have all these regulatory agencies, and they say, okay, we're going to make your food safe, your medicine safe. And so people just naturally trust them. But you look at something like what would happen in their absence if you had an underwriters laboratory, a Better Business Bureau for food and pharmaceuticals? Uh, uh, they might be far more strict. In fact, I guarantee you they would be far more strict than the FDA.
Well, that's the thing. A lot of free market and libertarian types, they sort of have a anti-authority and an anti-hierarchy and an anti, they're against rules. And I think that one reason they think they're libertarians is because they think that in a libertarian society you would have
do anything,
be a free for all.
Yeah.
But I think it could be the other way around. You could have far more private rules, and you would have to abide by them. I mean, no shoes, no shirt, no service. Something like that would always be
a superficial point, but I mean, but it would pertain to, especially to pharmaceuticals. I would think.
Yes.
You would have competitive and highly credible organizations out there.
Well, I've pointed out to people about, say, I'm opposed to trademark law because of, as I mentioned earlier, it's gone too far in some ways. And people say, well, if you don't have trademark law, then what's to stop, I don't know, someone selling knockoff Crest toothpaste in a supermarket? I said, well, think about it. You're going to go to the Kroger down the street, and they're going to stock Crest toothpaste from a knockoff Chinese supplier. Eventually, the consumers are going to find out. And then they're going to know that they can't trust Kroger to carry the genuine goods, right? I mean, it just wouldn't happen. The first time it happened, you'd go out of business. So you don't need trademark law or reputation or IP law to stop you from deceiving your consumers. You want to keep a good reputation and actually, to get your customers.
But it's hard to anticipate exactly how all this stuff would flesh itself out in the case of, and I don't want to get too far away from my my obsession with the FDA, but I just do want to point out that, you and I think, I don't know if you were with me, we were in the streets of Bodrum downtown, and where there's all these shops. And I remember distinctly that there was a real Nike shop, and right next door a fake Nike shop. Do you remember that?
You're talking about Bodrum, Turkey, and I was in Istanbul, Turkey earlier last year, and I was in the big market there, and I was with a local Turkish guy, and he was telling me that. So I was looking at all the fake purses, the knockoff purses, because in the U.S. they get destroyed pretty easily, but in other countries they're a little bit more lax. So you can find the knockoff Louis Vuitton and Chanel purses and things like that. But my friend Jay said, well, this street has the knockoffs, but this street has the genuine knockoffs. Like, they have different levels of knockoffs. There's real stuff, which is like $10,000. Then there's the cheap stuff, which is $100. But there's the genuine knockoffs, which are $300. Like, they're the really good knockoffs. They call them genuine fakes. It's crazy.
No, that's right. And there's another funny aspect to this. I think this happened. Tell me, I don't think I'm making this up. That Nike or whatever other kind of tennis shoe manufacturers realize that there's a certain utility to having a laissez-faire attitude towards the knockoff companies, because they could let the knockoff companies do product testing, right? So the knockoff companies make a fake Nike and a new shoe. If it sells really well, they know they should go into production with it or increase the production.
I mean, that could be true. It could be an urban legend. I have a feeling no Nike executive would concede your point on that. I mean, they're pretty, when they can use IP law, like in the US, to steamroll CDs or fake purses, they will do it. They will. And by the way, this is an example of the problem with trademark law. If trademark law was based, as it used to be, on the idea of fraud, which is consumer confusion, then it would not cover knockoffs, because in those cases the consumers are not being defrauded. No one who buys a fake Rolex for $20 from some guy selling it out of his jacket or van on the street of New York City is defrauded. They know that it's a fake. They're buying it because it's a fake. So the purpose of trademark law in those cases has nothing to do with consumer confusion or consumer fraud. It's just about reputation rights, which is again what defamation law protects.
Yeah, and right now on eBay, you can go on eBay and here a system again that regulates itself, right? So you can buy a real Louis Vuitton or you can buy a knockoff Louis Vuitton, and they are priced very differently, and the sellers will tell you this is not real, but it's really good. It's compelling.
I would be surprised. Are you saying you could buy a knockoff Louis Vuitton on eBay right now?
Yeah, sure. Yeah.
I'd be surprised at that because that would be policed heavily by the trademark fascists.
Well,
I
maybe
don't
I'm
know.
wrong about that. I think, well, it's a product. If it exists, why can't you sell it on eBay? I mean, you're saying
Because
that
it's a trademark. If it's trademark infringement, it can be stopped.
do you think there's no fake products on eBay?
I think it's the same reason you don't have knockoff books of Harry Potter on Amazon.
Oh, okay. Well, maybe I'm wrong about that. Maybe I'm wrong about that. In any case, so whether I'm right or wrong, and if you're correct, that just it proves that the market, which is another way of saying like human beings, are capable of policing this themselves. And to roll back to the FDA point, I think it was catastrophic that the FDA was created in the first place because first of all, they've got an impossible job. It was founded by industry, and now they're being asked to declare things safe and effective. Well, as it turns out, nothing in this world is perfectly safe, and nothing is perfectly effective. All right, so actually, in fact, nothing qualifies actually under a strict standard of safe and effective. Yet there are approvals going on all the time. So they're having to constantly toggle here. On one hand, acquiescent towards energy. On the other hand, having to maintain this ongoing fiction of safe and effectiveness. But every time they approve a product, they're taking away that sort of consumer natural caution that would exist among consumers. The same thing is true with food and meat too.
Yeah, totally agree. I mean, we have the Maha movement and things like that. You have some rolling back of some apparently bad nutrition advice and all this for like the last 30, 40, 50 years.
Yeah.
But that advice would not have had so much harm if people hadn't listened to it. But they listened to it because they listened to the government, because the government has taken charge of all these agencies and these safety protocols.
Yeah, and I lived through this. The upheaval of the American diet that happened, in the 1970s and following, would never have happened if we just stuck with grandmother's wisdom about food. And instead, we had this giant out there screaming, don't eat eggs, don't eat meat, eat more bread, and then everybody went along with it.
Although there was a time when even that generation was sucked in a little bit with after World War II, that era. They wanted powdered milk instead of real milk. They wanted margarine, and of course, partly that was the government. But look, my dad is 86 or 7. And he says something like, "I'm so old. I remember when bacon, eggs, and sunshine were supposed to be good for you."
That's very funny. But anyway, to your point, your point criticizing libertarians, there is this, and you say it's a criticism of me too. I used to assume that the great problem of regulatory agencies is that they're blocking products from coming to market.
Right.
Whereas, in fact, the real problem with regulatory agencies is they're permitting things to come on the market that in a world of purely private regulation might never have gone to market, not just because of the fear of consumer reaction to them, or that they aren't what they say they are, but also because of the liability that's associated with
Well, I mean, look at the COVID vaccine, which you have pointed out is not even a vaccine, I guess. But the FDA does block some drugs out of this concern for hyper safety. So they actually kill people by not allowing them to at least try something. At least Trump got the right to try, I think, done in his first term. But so they're overly cautious sometimes. But then that means that when they really want to make an exception, which they did for the COVID quote unquote vaccine, everyone assumes it's safe because the FDA only allows things that are safe, even though they did it under this exception, which no one understands, right? Which I think is still under that exception, right?
it still is, yeah. And the exception is the liability shield, which is one of the more remarkable features of any product that. So the COVID shot in particular has several layers of indemnification associated with it, right? So it was released under emergency use authorization and indemnification. That was put in place because of the PrEP Act, indemnification. Then it's added to the childhood schedule, which gave another layer of indemnification. Any shot on the childhood schedule is automatically indemnified against harm. You can't. Well, another way to put that is that the industry is indemnified. You can seek out damages from the government itself, but I mean they're hardly ever granted, and it's extremely arduous.
By the way, most libertarians, because they're sort of centralists and they worship the Constitution, they don't they don't distinguish between the states and the federal government, and so most of them don't even criticize the FDA and these laws based upon the idea that, number one, the FDA is unconstitutional because there's no power in the Constitution granted to the federal government to regulate pharmaceuticals in the first place. But there's also no power for the federal government to pass a law that changes state tort law, which is what these liability shields do. What they say is, same thing, by the way, the CDA and defamation law, which I'm against defamation law, but I don't think the federal government has the right to pass a law changing state tort law and defamation law. They also don't have the right to limit state liability claims in state courts, but they do that unconstitutionally with these liability caps.
So your solution to the FDA, I mean, this is a big topic, and I'll try to pivot away from it a little bit, but would be just to back up slightly, every time the Wall Street Journal says, no, your cancer drug sucks, no, you've got to take this thing back to trial, we don't believe that you really have a vaccine against Alzheimer's, this kind of stuff. Yeah. And they block it. Like my friend Vinay Prasad, who was hired by at the FDA, was this amazing scientist. And his tenure at the FDA, I think it runs out this month. Basically, it was pushed out, I'm sorry to say. But so he was at the desk where he would give the final approval off many drugs, and he looked at the trials, and he looked at the data coming in, and he just, in every case, he said, look, this sucks. This is not real. This is junk science. These trials you run are showing too many safety signals. This is not an effective drug. So he kept saying no, no, no to everything. And I'm cheering him on because I know he's right. I mean, he was always correct. But every time, but the Wall Street Journal, and I'm sorry to say, like the libertarian world or the liberty world, were raging against him as like some sort of despot who was denying consumers treatments that they desperately needed. But the Wall Street Journal must have ran like 15 attacks on the poor guy. But he was just simply doing his job. Right. So I think so. Your solution here is very interesting. It's like, okay, more drugs should be put in the category of you're free to try this. No, we're not going to approve it, but you're free to try it. And that would solve a lot of the problems. It wouldn't solve every problem.
No.
Because as you, I think, helpfully point out, the very existence of the FDA has crowded out what would have otherwise been a highly strictly regulated marketplace that would be focused on precision and would be competitive and would be adaptable according to market conditions.
I think I had a couple pieces previously, a couple years ago, on Brownstone about ways to improve the FDA process in relation to the patent system. Okay, so all these things are related. The intellectual property space, which is patents, copyrights, also trademarks, but also defamation law, as I mentioned, reputation rights, and also tort liability. All of this is related. The argument for patents is that it's really needed for products that are high cost and easy to replicate, like pharmaceuticals, but of course the cost is so high because the FDA cost is high. So
and by the way, the industry likes this, right? I mean, the industry likes high costs of FDA approvals because there's very few companies that can bear them.
Right. But so if you wanted to do some reasonable, modest reforms, one thing you could do is you could say, listen, well, we should reduce the cost of FDA. One way to do that would be to give a right to try. Let's say if I want to opt out, I can opt out. So let consumers choose, get an unregulated drug if they want. Another would be to say, okay, if the costs of the FDA regulatory process are so high that it justifies patents to protect you from competition, well, you could say anyone who gets the follow-on or the generic right to make the generic, if you don't have a patent, the FDA has to say the second guy has to pay a pro rata share of the cost the first guy paid. So that would be one improvement. So like the second guy would have to pay half the cost the first guy paid. And then the third guy would have to pay 1/3 to the other two. So that would be one way to make things you wouldn't need patents wouldn't be justified by that anymore. And another way would be to just go back to the old principles of the tort law, and contract law, which is caveat emptor, buyer beware. Yeah. I do think that the tort system should be reformed so that you should not be able to sue for something you voluntarily took as long as you weren't defrauded. If you sign a waiver saying,
Exactly, which is a very interesting proviso here, because it's not the case. I mean, I'm all for strict liability here,
right?
Especially when it comes to pharmaceuticals. If I take something that harms me, I should be able to sue and make a lot of money, for all the harms, and that is currently not allowed for a vast range of some of the most common pharmaceutical, particularly injections, right? So that to me is outrageous. But your point about, so there's two mitigating factors here that keep strict liability from becoming overly burdensome. One is that a manufacturer has to be insured, right? So so suddenly the burden is on the insurance company to do a realistic assessment of genuine risk. So insurance then becomes a really important player. And the second one is the point you just made, about safety waivers. I mean, if I went out this afternoon and I decided I wanted to try skydiving, first of all, they're not going to let me skydive until I've gone through 45 hours of training or whatever. But secondly, there's going to be a phone book, if anybody remembers what those are, phone book size liability waivers, right? I'm going to have to sign a lot of papers saying that I will not be able to hold you liable, and that's entirely in keeping with a market ethos too, isn't it?
Absolutely. Yeah, I totally agree with you. Look, but I do think that caveat emptor should be the default rule. You should be buyer beware. I'm not even so sure about strict liability. I think that's debatable. That's a nuance, whether we should have strict liability or not. But basically, there should be liability for harm. But there's all these legal questions about whether there should be a default warranty or guarantee, or what should be the default presumption. But to me, that's just a question of contract law and tort law.
Mm-hmm. Okay. Yeah. So There's I don't want to keep going back to this, but I mean, the elimination of the indemnification against an entire class of pharmaceuticals seems to be like an urgent change. But just, and we're not anywhere close to doing that, but it should be done. I think that would just cause a whole range of products to be never pulled off the market and never manufactured again. Actually.
I think that's likely, but unfortunately, it's heavily distorted right now. Unfortunately,
yeah, and it's been distorted for 125 years. So, caveat emptor is a Latin term I was looking for early in our interview, and it just slipped my mind. But that's right. The buyer should be aware, regardless of the existence of these regulatory agencies. The fact that these regulatory agencies exist like they disable that natural market mechanism that would be in place and throughout the consumer marketplace.
Yeah, there must be another Latin variant of that, caveat something like caveat citizen or whatever that means. Like citizens should not really trust what the states. And I think that's we saw that happening. I mean, I think before COVID, the average person, someone like me, I might have been somewhat skeptical of some medical advice, but I assumed vaccines worked and all these things.
Stephan, I was exactly the same way. I never had any doubts about this. I mean, by the way, I didn't assume the vaccine would work, but I never imagined that would actually be unsafe, right?
Right. So I think you have lots of people who now don't know what to believe, and I think that's probably a good thing. And of course, if you're just skeptical of what the state says now because you live in the real world, you're called a conspiracy nut, or you're called a kook or a crank by the mainstream establishment types because they're nervous that people are catching on to the fact that the state is full of lies and deception.
Yeah, and now to bring us back to the defamation point, which is in a funny way, your most provocative and interesting assertion during this interview, which is really so fascinating to me. But caveat emptor should also apply to the consumption of information, right?
Exactly.
And
yeah, again, yeah.
And so to tie it all up, in the same way that the FDA provides a kind of an illusion of safety and effectiveness,
Yep.
The existence of defamation law wraps all information services in an illusion that they're non-defamatory.
Yes. And I mean, something like that happened during COVID when speech was censored on Twitter. So because you couldn't say certain things on Twitter, everyone assumed that what was said was past the minimum standards for acceptable talk. So it all ties in together.
That's one reason we had a really hard time getting through. And even to this day, I've always puzzled about one feature of this period in our lives that was so traumatic. The dominant assumption is that the public just rolled over and let this happen to us, right? We let Fauci preach to us, stay 6 feet apart, and we complied. Stay home orders, we complied. Shut down your business, we complied. Nobody objected. We all just trusted the elites. I'm not sure that is true. And the reason I'm not sure it's true is because of all the censorship. We actually don't know how much population resistance there really was, because the information was so throttled.
Right.
I think it's an empirical question. I don't know. I mean, well, Stephan, thanks so much for this wonderfully and engaging interview. Your book is called The Legal Foundations of a Free Society. Yeah. Let's get that baby out here. That is a massive. Show the thickness of it. That's just the cover. Yeah, the thickness. We're talking about what, like 600 pages with.
It's about 1/2 footnotes. Yeah.
Yeah. with.
And by the way, the defamation piece the defamation piece came, that was 2023. The defamation piece came out in 2024 in this Hoppe book. So my defamation article is in this book.
Okay, so you're going to have to do a new edition of Legal Foundations of Free Society.
I got to find a publisher that has a binding that goes that thick.
Oh yeah, you bumped up against the limits there, huh?
Yeah, if you're 800 pages is all that Amazon Kindle publishing will do in hard copy. So I had to go to Ingram Sparks for that because I'm 808.
That's really something, Stephan. Such a pleasure to see you, and
You
really
too.
glad to have you on Brownstone Show. All the best.